Question 2. Green Godzilla Company Limited is a juristic person under Thai law. According to its constitutive act, the MOA, and regulations, AOA, its objects is to trade used cars, okay? Red, white, and pink, as members of the board of directors, okay? According to its MOA and AOA, each board member alone can enter a contract for and on behalf of the company. Oh my god. And on behalf of the company, the value of the contract is no more than 1 million baht. But if the value of the contract is more than 1 million baht, all the board members must and sign it. On 1st April 2020, 1st April 2020, Pink resigned from all positions at the company, including a member of the board of directors. Her resignation was complete in accordance with the company's AOA and took effect on 1st August 2020, On the same day, the shareholders appointed a new director in place of Pink. The appointment followed the AOA and took effect on 1st August 2020, However, Pink's resignation and Brown's appointment have not yet been registered at the government agency. Okay, that's important. Oh my god. Forgive me, I am a bit under the weather. Consider the additional facts and answer the questions below. Okay, so based on the facts above, 5th August 2020, that was after Pink resigned and Brown has been appointed. Brown offered to sell used cars, while the used cars to the company for 50 million baht, which is much lower. Since it is 50 million baht, I can already say that all the members of the board of director must approve and sign of this contract, so all members, which is much lower than the market price, Red, white, and pink all agreed, pink, agreed that the offer was a good idea for the company. They believe that since the change of the director has not yet been registered yet, Pink could approve and sign the contract. Forgive me, oh my god. I do not know what's happening. Therefore, Red, White, and Pink approved and signed the contract by buying 100 used cars from Brown for 50 million baht. Is the company bought by this contract? First, we look at section 66, which is the objects of the company. Objects of company. Section 66. I will admit I cannot remember the exact provision, but the objects of the company, section 66, it specifies like the scope of a company's objects and what it can do. And within this, it has been specified that the object is to trade used cars, buying and selling used cars. So yes, it falls under the objects. Next, we look at like section 70, like who the representatives of this company, and is there any oh lord, no. Since it falls within the objects of the company, then we further assess section 70. Does the company have one or more representatives for the juristic person? Yes. Section 71, which applies to the majority rule, if it is not prescribed within the Articles of Association about the decision making of the juristic person, which in this case it did. Therefore, section 71, you raise it, but you don't apply it. And then section 72. So basically, if there has been a change of representatives, in this case, yes, there has been a change of representatives, and the change takes place immediately after compliance and approval of the board in accordance with the AOA 72. So, yeah. And in this case, oh my god. So basically sections, I did a little mistake there. No need to go to section 72 yet. We go to 71. So if majority rule does not apply, and it has been specified within the AOA on the number of representatives needed to do a contract for the juristic person, then yeah, it has to comply with that. And in this case, firstly, we assess whether or not Brown is is there any conflict of interest in Brown doing this contract? We go to section 74, which pertains to conflict of interest. And in doing the conflict of in assessing conflict of interest, it's the representative of the company has to be like in both the buying, has to do both the selling and the buying in order to raise conflict of an issue. And in this case, the Brown was selling 100 used cars to the company, to, in this case, who would be red and white only, since pink is no longer a part of the board of directors. And there is no issue of conflict of interest, but there is an issue on the number of legal representatives, since it is specified within the AOA that any contract exceeding 1 million baht it is bound. It has to be done by all the representatives of the company, the juristic person, whatever. So it has to be all, meaning it can just be red and white. Since pink is no longer a representative pursuant to section 72, which states that the decision takes place right after compliance with the AOA, meaning that on the 1st of August, pink is no longer a rep. So in doing this contract, it is red and white. And to do this contract, Brown also has to be on the part of the buyer, not the seller. Because at the time of doing the contract, he is a rep, and at the time of doing the contract, at the time of doing said contract, he is a rep, and since it has been specified within the AOA that it needs all board members, he has to be the one signing the contract as well. Therefore, the company is not bound by this contract, since there is not a sufficient number of there is not a sufficient number of representatives for this contract, since pink is no longer a representative pursuant to section 72, and Brown was not acting as part of the representatives pursuant to the Articles of Association in compliance with section 71, pursuant to this of the company, and in pursuant to section 71. And there is no conflict of interest, since Brown was not acting in his own interest, since he was doing this act on part of the seller, and not on both sides of the contract, or something along those lines. Oh my god. Okay. Based on the facts above, 5th August 2020, Brown, on behalf of stationery from M for 50,000 baht to be used in the office of the company, red and white, argued that this contract does not bind the company because 1, it was not approved by them, 2, it fell outside the scope of the company's objects, and 3, Brown is not officially a director of the company, and his appointment has not yet been registered. Are there arguments 1, 2, 3 valid? No. So first, it was not approved by them. It does not need to be approved by them, since it is specified within the Articles of Association that any contract that is less than 1 million baht, each board member alone can enter into. Therefore, the first argument is not valid, since Brown, who is now practically considered one of the board of directors of the company, can do such contract for the company. 2, I answered 3 as well, but I could just say, it was not approved. No need to be approved. 2, it fell outside the scope of the company's objects. So we go back to section 66, and the objects of the company can either be express objects or implied objects of the company, and it did not fall outside of the scope of the company's objects, since it is obvious that a company would need stationery for its day-to-day function. A company, it is implied that a company would need to acquire stationery for its day-to-day operations to be used within the office of the company, whatever. Brown is not officially a director of the company, as his appointment has not yet been registered. Are there arguments 1, 2, 3 valid? Okay. So Brown is not a director of the board of the company due to the registration, but pursuant to Section 72, it is stated that the decision is effective right after compliance with the AOA and on the day of 1st August, since Brown has been appointed as the director. Even though it hasn't registered yet, he is considered as a director. He's still considered as a director, and regardless of the registration, the use of registration can only apply to a third party who is acting in good faith, who enters into a contract believing that Brown is still one of the directors of the company, but which in this case, Brown is a member of the board of directors of the company. So, yeah, 1, 2, 3, not valid. I said that I said it very. Did I say too little? No, I feel like I yapped enough. Okay. Based on the facts above, 5th August 2020, Brown, whose appointment has not yet been registered, ordered Pete, an employee of the company, to injure Bill, a customer of the company, who insulted Brown. Bill wishes to sue the company for compensation. Are the company and Brown jointly liable for Pete's wrongful act? And I believe that is what section is that? Okay, so yeah, section 76, which would be the rep, empowered person, commits tort, or wrongful act, and it is well within the range of the objects of company. Okay, so rep, empowered person, Brown, empowered person, Pete, commits tort, wrongful act. Pete commits the wrongful act. Yes, to injure Bill, customer of the company who insulted Brown. Bill wishes to sue the company for compensation. Are the company and Brown jointly liable? And this is how you interpret the objects, or the, what's the Latin word? You know what? I don't know the Latin word. I forgot the Latin word, but there is a Latin word for it. Yeah. So there's a range of the company, and the objects of the company would mean like within the working hours of the company, or like the working time that the company functions, basically. So you could say, I would say, that it is well within the objects of the company, since this is an establishment which its object is to trade used cars, and if there be a customer there, it would mean that the customer is there physically, and it would not be outside the range of the working hours of the company, since the customer himself was still there, and Brown still had the time to order Pete to commit such a wrongful act, and therefore Bill can sue. Yeah, Bill can sue, and the company and Brown are jointly liable for Pete's wrongful act. Therefore, the company and Brown must pay compensation towards Bill for the wrongful act. Therefore, Section 76 applies. Oh wait, since it satisfies all conditions of Section 76, the company and Brown are jointly liable for Pete's wrongful act. Thank you very much. Hope you guys have a nice exam. I hope I don't. Yeah. Okay, thank you very much.